internet.
Hi, Yogita. I don't think the other judge is online. I don't think they've joined. Can you please check?
Yes, ma'am. Just a moment. I have actually added sir a moment ago. I will be right back. I think he.
Yeah, please check.
Ma'am, I'll be right back. Hello, Dhyanshu. This is Yogita. This session is being recorded. You can go ahead and start the session. Can you hear me, Udyanshu? Hello? Can any of the speakers confirm if they can hear me?
Yes, ma'am.
Okay, just a moment. Udyanshu, can you hear me?
Is he audible now?
Yes, you are audible now.
Oh.
The session is being recorded, Udyanshu. You can commence the session.
Okay, okay. Have you started recording the session? Yogita, this is being recorded, right? Yes.
Yes, sir. Yes, sir. It is showing as recorded.
Okay, you can start the session with all speakers and judges have joined. And you can please put all the judges and speakers on spotlight.
Are we waiting for one more, the other one?
One of the judges has not joined yet. Who's the other judge? Please speak out. How many people are there? I will speak. I will call.
Section 45 talks about capital gains taxation. Section 28 clearly defines income which will be charged under the heads of profits and gains of business and profession. However, none of these sections clearly specify virtual digital assets, nor give a cause for us to interpret and infer the taxation of virtual digital assets under any given heads. Further, it is nowhere defined, virtual digital assets are nowhere defined under the Act. And
But that's okay. They are doing so after the insertion of this section. Is there anything, I mean, is there anywhere laid in the law that you can't introduce any new provisions or new definitions?
The council would like to explain that, Your Lordship, without defining something, we cannot provide a law which taxes that certain thing. The Income Tax Act has to include under it its ambit.
Ma'am, sorry for the inconvenience. We'll just wait for 5 minutes more. Aman sir is having some technical issues on his end.
No worries.
Good morning, ma'am. Good morning, sir. We will commence the session now. All the speakers, we just want to inform you the time breakup before we go ahead with the session. We've already informed this earlier, but just for your reference. Each team will be given 30 minutes, and by default, each speaker is considered to be given 15 minutes. If you require more or less time for any specific speakers, kindly indicate us so that we can time you accordingly. Any time left over from your arguments from the 30 minutes that is assigned to your time will be considered for rebuttals and surrebuttals. If there is no time remaining, 30 seconds is allocated for rebuttals and surrebuttals to each team. We're very pleased to have you, ma'am and sir. All the speakers can kindly switch on your cameras and we may proceed with the session. The Petitioners Council can start the session now.
Hello, am I audible?
We can hear
Yes, you're audible.
Yes, sir.
Yes, please go ahead.
Your Lordship, the Council seeks permission to begin.
Yes, please begin.
May it please the Honorable Court, that is the Council appearing on behalf of the petitioner in the instant case. The Petitioner Council will be specifically dealing with the issues that whether or not the government is justified in taxing digital currency, digital assets, and NFT, which are not legalized, and whether or not Section 115 Clause BBH of the Income Tax Act is a violative of the Constitution of India. The first issue will be dealt by me and my co-counsel will be dealing with the second issue. With your Lordship permission, may the council proceed with the facts of the case.
Yes, please proceed.
The Republic of Parlamento, which is a secular, socialist, and economic and democratic nation, in the recent times, which has gained the popularity in the International Nations Organization for boosting its economy. During the COVID pandemic, there was a rise in illegal digital assets and their transactions. In the absence of an appropriate legal framework of a virtual digital assets, digital currency, and NFTs, which are non-fungible tokens, government implemented a new tax regime aimed at taxing gains or income from the virtual digital assets at 30%. The citizens of a nation were perplexed and they filed a special new petition. And these are the facts. If your Lordship are well versed with the facts of the case, then Council would like to proceed with the argument advance.
Counsel, why don't you give us a brief summary of the facts of the matter? Not too lengthy, not too detailed, but a brief description. That would be great.
Okay. I will present the facts again. The Republic of Parlamento, which is a democratic country, which is also secular, socialist, economic nation. In the recent times, it has gained the popularity in the organization, which is named as the International Nations Organization. Almost every country in the world who is a member of this organization, and the Republic of Parlamento has gained the popularity for boosting its own economy. And after all know, during the COVID pandemic, there was a rise in digital assets and their transactions. So government implemented the new tax regime, even in the absence of an appropriate legal framework of a virtual digital assets and digital currency and NFT, which are non-fungible tokens. And they implemented a new tax regime and aim at taxing gaining income from the virtual digital assets at 30%. So the citizens of a nation were perplexed and they filed a special leave petition against this tax regime. And the two issues were framed that whether the government is justified in taxing such a digital currencies, NFTs, which are not legalized. And the second issue was whether or not the Section 115 Clause BBH of the Income Tax Act, which is violative of the Constitution of India. If your Lordship is satisfied, then the Council would like to proceed.
Yes, please proceed.
Treating cryptocurrency with the other DLTs under the umbrella of a term of a digital virtual assets is not justified, and imposing taxes is a violation of law. How I will explain. In relevant finance bill of the ministry, finance made attempts to define the virtual assets and currency and consolidated all the attributes of a distributed ledger technology, which is known as DLT, and the blockchain like a cryptocurrency and NFTs into the definition of virtual digital assets rather than defining them separately. The definition is vague and lacks the clarity as a difference between the VC and the VDA, which is virtual currency and virtual digital assets, as they have different features and they cannot be treated equally for the taxation. Cryptocurrencies not being an Indian or foreign currency. The specific terminology used under the Income Tax Act is any information or code or number or token generated through the Cryptographic means, or otherwise by whatever name called, providing a digital representation of a value exchanged with or without consideration with the promise of representation of having an inherent value or functions as a store of a value or a unit of accounting, including its use in any financial transaction or investment, but not limited to the investment scheme, can be transferred, stored, added electronically, such as NFTs or similar token as the central government may notify, such as digital assets the central government may notify. Curiously, the Income Tax Act does not mention either blockchain or DLT in the definition of the virtual digital assets. The central government has yet to notify the NFTs, tokens, or other virtual digital assets to which provisions of the Income Tax Act will apply. While it may therefore be argued that no NFTs are presently covered by the new tax regime, and there is a possibility that the tax authorities will elect to tax NFT under the cryptocurrency head, as the definition includes tokens, may be considered wide enough to include NFTs. It would therefore be prudent for taxpayers to assume that the NFT they acquire, sell, or otherwise deal are likely to be taxable under new regime. And there are many difficulties may arise determining the taxpayer's taxable income or gains from the receipt or transfer of the virtual digital assets. Where a VDA is received without the consideration or for a consideration lower than the fair market value, difficulties may arising in determining the person's taxable income in respect of the asset. Cryptocurrencies and NFTs are generally extremely volatile, with the valuation of fluctuating on a regular basis. Therefore, it may be difficult to pinpoint the fair market value of the asset. Where the cryptocurrency is purchased on the crypto exchange or NFT is purchased on the marketplace, it may be generally argued that the fair market value is priced previously on the exchange or the marketplace at the time of the purchase. However, this may not hold water with the income tax authorities, as fair market under the Income Tax Act is to be determined in accordance with the Income Tax Rules 1962. While the rules do prescribe mechanism for determining the fair market value of the various assets, they do not specifically deal with the valuation of the VDS. This is creating the lacuna. Problems may also arise when a person is liable to tax on transfer of VDA. There is only deduction permitted on the income earned from the transfer of the VDS is the cost of acquisition, where a VDA is a purchase and sold for identified amount in a Indian rupees or in a foreign currency. The income of the cost acquisition are easily identifiable. However, if the VDA is acquired using or sold in an exchange for another example like NFTs purchase using the Bitcoin, the cost of acquisition or a consideration for the transfer of VDA may be difficult to ascertain as a specific Indian rupees value for the acquisition, or the transfer will not be readily available. The difficulties in valuing VDA for the purpose of taxation could lead to dispute with the tax authorities. The government has also confirmed the expenditure incurred in mining cryptocurrency is considered as a capital expenditure and not cost of acquisition. Therefore, considerable expenditure on the hardware required to mine a cryptocurrency cannot be deducted from any income derived from the transfer of cryptocurrency. While no clarification is available in respect of the deduction of the cost incurred to the mint NFTs, this will likely be treated in the same manner as a mining cost for a cryptocurrency. And then again, no set off or carry forward or losses. The Income Tax Act expressly prohibits that the set off of losses from the transfer of the VDS against income or gains derived from the VDS. Illustratively, if a person were sold to an NFT and incur a loss, the loss cannot be set against the gain made on the transfer of the virtual digital assets. If A sells an NFT artwork for a loss and rupees 10,000, then sells a Ethereum for a profit of rupees 50,000, A would be liable to tax on entire profit of rupees 50,000 from the sale of Ethereum, and would not be able to set off the losses on the previous 10,000 NFT which he incurred the losses. Essentially, under the Income Tax Act, gains and income from the VDA are taxable, but not relief is provided in the event of the losses are incurred. And to that extent, the VDAs are taxed differently than most other assets in the India. The Article 265 of the Constitution of the India clearly says that the no tax shall be levied or collected except by the authority of the law. It means that taxation is an essential feature of the government of India, and it cannot be determined on the basis of the assumption. The question arises whether the trading bitcoins or virtual digital assets will a business income, and if it is a business income, whether it should be covered under the head of the income from a business or a profession. Since the video is not a capital asset, it may not be covered under the head of a capital gain, but being an asset and the trading of a such asset should be covered under the income of from business and profession. And if so, that all the expenses incurred for earning the income should be also followed, rather than restricting it to the cost of acquisition of the virtual digital assets. The classification test has been a component of a non-arbitrariness that permits the assessment of a state action to make it sure that non-arbitrary from the purpose of view of equality. The talk on the selection between the old doctrine of a reasonable classification and therefore a new doctrine of a reasonable arbitrariness overlooks the fact that normal equality test is a component of a non-arbitrariness and interpretation of the Article 14, which deal with the many conceptual concerns in the understanding and interpreting the relevance of a non-arbitrary assessment of Article 14. The Supreme Court of India, in the case of Internet Mobile Association versus Reserve Bank of India, virtual currency stated that the virtual currency can have a unidirectional or a bidirectional flow of depending upon the scheme, which is the entities come of. Therefore, different types of virtual currencies require different treatments. In the Amit Bhangarao versus the Union of India, Supreme Court also asked the government of India to classify the legality of the cryptocurrency in India, and the government yet to give a clarification on it. The Supreme Court in A.V. Fernandez versus State of Kerala held that no tax can be imposed by the interference of the analogy or by trying to be probe into the intention of the legislature by the considering what was the substance of matter. Therefore, my submissions to the honorable court that the government is not justified in taxing the cryptocurrencies with the 30%. Much obliged.
Like you just mentioned, the government is not justifying in imposing the tax for 30%. Do you by any means mean that 30% is a higher taxability rate and it can be something lesser? Would that be justified? If we bring the bar from 30% to say 15%, do you think that would be justified?
Your Lordship, yes, I agree with you, but it's not all about the rate of taxing. It's about the equality. You are treating the cryptocurrency arbitrarily and other assets differently. So there must be some regularity in the taxing the assets, whether it may be the virtual digital assets or whether it may be the capital asset, personal asset. There should be equality. It's not all about the rate of tax.
Okay. Your other speaker may start. Resume.
Yes, Ladies. Warm greetings, Your Lordship. With your Ladyship permission, can I address the court collectively as Your Lordship?
Yes, that'll be okay.
Much obliged. Your Lordship, as far as issue number 2 is concerned, is whether or not Section 115BBH of Income Tax Act is violative of the Constitution of India. Your Lordships, this online digital assets such as cryptocurrencies, there are many other varieties into the digital currencies, which is fungible in nature and its value changes as the community involved in this transaction and its worth fluctuates with increase and decrease in supply. Further, the transaction of specific online digital currencies token can only be taken place in its restricted ecosystem. For example, Ethereum cannot be used for any transaction in the Bitcoin ecosystem. They have separate ecosystems altogether. In this ecosystem, Your Lordships, an end user request for the token, miners on the other end mine this request and put it in a block. This request is stored in the cryptographic codes in the block. Another group of miners mine this codes and once found out, arranged with another block that makes this blockchain altogether. So entire this currencies are based on blockchain technique. Your Lordship, as far as the case of this honorable court is concerned of India in Internet and Mobile Association of India versus Reserve Bank of India, petition 5 to 8 of 2018, where it was held that virtual currency can have an unidirectional or bidirectional flow depending upon the scheme with which the entities come up. Therefore, different types of currencies can have, therefore, different types of currencies requires different types of treatment, your lordships. So if we are taking just the digital currencies, there are varieties into it. Just one straight jacket formula cannot be applied for this virtual currencies. Also, in the case of Amit Bhargava versus Union of India, this court also asks the government of India to classify the legality of this digital currencies, and the government is yet to make the clarification on it. Also, in the case of A.V. Fernandez versus State of Kerala, held that no tax can be imposed by inference or by analogy or by trying to probe into the intention of the legislature. So as far as section 115 BBH of Income Tax Act, which reads as, where the total income of an assignee includes any income from the transfer of any virtual digital asset, the income tax payable shall be aggregate of, is very important, subpoint A, the amount of income tax calculated on the income from transfer of such virtual digital asset at the rate of 30%, your lordships. Also, it has been said that in the next point, the amount of income tax with which the assignee would have been chargeable had the total income of the assignee been reduced by the income referred to in clause A. So as far as clause A is concerned, directly 30% of interest is charged on this. Your lordship, as far as the facts of the case is concerned, when the entire world is in the pandemic, and not only the Republic of Parlamento, but also many other countries in the world are trying to gain some income out of the digital market, which is not only going to uplift them, but also the entire economy. So in such a time where all the citizens stuck in the pandemic are trying to uplift, but at the same time, the government is charging 30% tax, which all the citizens have made the decision that why this is unreasonable when there is no law legalizing such currencies. So, your lordship, when there is no law legalizing such currencies, it is violative of the constitution of Parlamento. There has to be some regulation, there has to be some rules. If I go back to the golden age where there were no n number of people, there was no population, there was no need of currencies, where people used to have barter system that was not regulated, that was not having any rules and regulations. But as far as we got evolved, there were currencies which has been regulated by the government itself, because there is population, there are frauds happening allwhere. Therefore, the regulation is important. And as far as this digital currency is concerned, large number of debates happening around the world, because which is not centralized, which is in itself decentralized currency, which has no any such law which is going to make or give the citizens who are found in the fraud, so there is nothing out of it. Therefore, when there is no such law made on such decentralized currencies, there has to be something made. Therefore, it is violative of the Constitution of Parlamento, Section 115 BBH of the Income Tax Act.
Could you summarize your grounds in 5 points about
Yes.
this law being unconstitutional? Give me 5 points.
Yes.
You needn't elaborate on them. Just give me 5 points as to why you think this is completely unconstitutional.
Yes. My first point, Your Lordships, is Article 265. My second point is it's digital, decentralized. My third point is there are varieties of currencies which needs rule. My fourth point is when there is a open way for the citizens to gain some economic benefit, at that time government rather uplifting, they are demotivating. And your ladyship, my last point is the article acts as an armor instrument for arbitrary tax extraction. So these were my 5 key points for keeping this issue number 2, which is violative of Constitution of Parlamento.
What is your
Also,
interpretation? Sorry, please
yes,
proceed.
I'm
Continue.
sorry, Your Lordship.
No, please continue.
Yes. So as just moving on for the prayers in hand, if Your Lordships are.
What is your interpretation of Article 265? Either of you all can answer, you or your co-speaker.
Shall I answer this question?
However, it's upon
Yes,
you.
yes. Sure. Article 265, which read as, without the authority of law, no taxes can be collected in what this article simply means in the terms. So if
So
Your
do we
Lordship,
not, does this section not have the authority of law? It has been passed by.
it has been passed by the legislature,
Yes.
but at the same time, Your Lordship, it is not legalized. Before passing such act, such bill, on what they are passing, that such currencies has to be legalized, without which there is no any fundamental hold for the act itself. Therefore, it is violative of Article 265, Your Lordship. If I may point out one case on this, that would be a crystal clear thing.
Sorry, you're not audible to me. You're not audible to me. No. Can you please check your mic?
There is some network issue at my side. The timekeeper, could you please tell us how much time is remaining?
You have
That's okay.
5 more minutes.
Yeah, you
All
please
right.
proceed.
Yes. So in this case, Your Lordship, the villagers who are paying 50 rupees per day to the headman.
Please cite your case again. Because of the network issue, we couldn't.
All right. In Tangkhul versus Simirai Shalai, the villagers were paying 50 rupees per day to the headman in the place of a custom to render a free day's labor. This was done every year and the practice had been continuing for generations. The court in this case held that the amount of rupees 50 was like a collection of tax and no law had authorized it. So, Your Lordships, unless and until the currencies has been authorized by the legislature, by the government, how would the tax would be applied on such currencies which are in first place not taxed, not made lawful, and therefore it was violative of Article 265. This was the case on this, Your Lordships. If Your Lordships are satisfied with issue number 2, Council would like to proceed with prayers in hand.
Yes, please.
Council, I have one question. You've said that you
as far as issue number 2 is concerned, can you show me any particular provision or any regulation for that matter which categorically sets out that cryptocurrencies and digital assets as a whole have been declared to be illegal in India? Sorry, in your parliament.
Yes, yes, your lordship. Yes, your lordship. The cases relating to this digital currencies, which have not been specifically, which has been also clear in the fact where the government is not making it illegal. Yes, where it has, yes, also the court has not made it illegal. There has to be some rules and regulations which has to be sorted out.
So
and
you're
which
saying
has,
that the lack of a set of rules and regulations and a lack of a policy for that matter.
yes, yes, your lordship. Unless and until, uh, unless and until there is some policy made, there is some rules for the legal, for the digital currencies to be governed, which would not make any of citizens' loss, which would be, which would never be compensated by the government because it is not regulated. So if this such things happens, because the cost of these currencies are huge in number. Also, this is bought as an asset in today's time. So, there being such a huge risk, the government should make first
The point here is that you submitted earlier
yes,
that there is no, and correct me if I'm wrong, but my understanding of your submission was that you said cryptocurrencies and digital assets as a whole have not been legalized yet.
it has not been legalized as such, but there is no illegality by the court itself.
That's
By
all
the
that I wanted to
government
bring
itself.
out.
Yes, so that what I'll make it clear, your lordship. So unless and until this case of Tankul versus Shimira is concerned, where there is no any legality of the currencies or the digital assets, whatever is concerned, unless and until it is made legalized, there cannot be such a huge tax applied to it because it is violating of Article 265.
You see, can't possibly run afoul of Article 265, no? Because if it is being taxed, it's being taxed with the authority of law. First things first. Second thing is that as far as your bitcoins and cryptocurrencies as a whole are concerned, look, you have to go back to the principle involved. The principle involved is simply this: that any income that accrues from trading of cryptocurrencies is liable to be taxed.
Yes, your lordship. But Article 265, which reads as without the authority of law. If we take into account section 115 BBH, which just says virtual digital assets, but the issue itself says that, I'll read the issue: digital currency, digital assets, NFTs, etc. So there is not one single thing under the scope, under the umbrella of this section 115 BBH. So it has to be somewhere be specific when there is such huge number of tax gained from such asset.
Right.
That yes, if your lordship is satisfied with the issues in hand, may I
Proceed with your
proceed with the
prayers.
prayer? Yes. Wherefore, in light of the issues, measures at issues, legal pleadings, reasons given by authority cited, the petitioner respectfully submits before the Honorable Court of Parliament or further prays for the court to the writ petition be allowed. The said section imposing tax on digital currencies at the rate of 30% be declared unconstitutional and be quashed and set aside. Much obliged.
With the permission of the learned judges, the other side can start the session.
I think they can begin.
A very good morning to the bench, to the honorable bench. I am speaker 1 from team 6 and I will be representing the case on behalf of the respondent. And the counsel would be dealing with facts of the case, statement of jurisdiction, and the first issue of the case, and second issue and the prayer would be taken up by my co-counsel. The counsel seeks permission to proceed with the facts of the case.
Just a brief summary, not too detailed.
So much obliged, Your Honor. The facts of the case say that there is a country, Republic of Parliamento. With a population of 140 crore, and it is the largest democracy in the world. And in the recent times, the technology has increased a lot, and it has developed a lot, and it has even integrated a lot in the lives of people. There is an increase in the transaction in between cryptocurrencies, NFTs, and other digital assets in the blockchain sphere, which has led to the mainstreamization of these technologies. So hence the government has decided to come up with a tax of 30% to tax the income earned through the transfer of any of these digital assets. And the people of Republic of Parliamento have decided to challenge this tax in the Supreme Court. Because these assets have not been legalized yet. The council seeks permission to proceed with the statement of jurisdiction. Under Article 32 of the Constitution of India, the Supreme Court of India, the Supreme Court has the jurisdiction to deal with this particular case and the writ petition signed by the petitioners. And the council seeks permission to start with the first issue of the case. Much obliged, Your Honor. The first issue of the case is whether or not the Republic of Parliamento is justified in taxing cryptocurrencies, justified in taxing income earned through cryptocurrencies, NFTs, or other digital assets when it has not been legalized. So the council would like to say that the government of Parliamento is completely justified to tax the income earned through these assets, as this step to tax the income earned through these assets is the first step to regulate these assets, and any kind of technology or a new subject needs regulation irrespective of its legal status. So even though it has not been legalized yet, it is important to start regulating it, and it is all the more necessary here because of the anonymity that blockchain technology offers. The council would like to proceed with the first argument. The first argument we are presenting here is virtual digital assets can in fact be classified as capital assets. The Section 2, subsection 47A of the Income Tax Act says that cryptocurrencies, NFTs, or any other digital assets included in the are included as virtual digital assets, and any other digital assets mentioned by the central government in the official gazette. And Section 2, subsection 14 of the Income Tax Act defines a capital asset as any kind of property owned by the assessee, whether or not related to his business or profession. And this definition of capital assets encompasses all types of property, excluding those specifically mentioned under this act. And as cryptocurrencies or NFTs have not been specifically excluded from the ambit of this definition, we can classify them as capital assets. And it was also held in the case of Commissioner of Income Tax versus B.C. Srinivasa Shetty that this definition of income tax has the broadest range. This definition of capital assets has the broadest range, and any kind of property can be included based on its based on its qualities as a capital asset. Hence, we can treat income earned through these virtual digital assets as capital gains, and the union government is well within its ambit to tax the income, as the article 246 of the Constitution of the Constitution gives the power to union government that it has exclusive right to tax the income earned as capital gains. The council would seek permission to proceed with the second argument. The second argument would like to present is that the legal status of virtual digital assets does not have any bearing on its taxability. Further, we would like to say that there have been many instances. There have been instances where the legal status of the source of income was not taken into consideration while imposing the income tax on it. For instance, in the case of Muhammad Abdul Karim versus Commissioner of Income Tax, although the business carried out by the partnership firm was illegal, it did not have any effect on the payment of their taxes. It was held that they would still have to pay their taxes, pay the income tax, irrespective of the legal status of their business. This judgment was based on the case of Mann versus Nash, where Justice Rollins had said that the state only looks at the revenue earned, the accomplished fact, that is the revenue earned by the person. The revenue laws say that the income earned, any kind of income, has to be taxed by the state. And the same was held in the case of Commissioner of Income Tax versus S.C. Kothari, where it was said by the Supreme Court that if a business is illegal, neither the profits nor the losses incurred, neither the profits earned nor the losses incurred would be enforceable by the law, but that does not take away the income earned from this taxing statute. And the next case is I would like to present. The council would like to present.
Before you proceed, there's one question, council. You are seeking to justify the existing regime. The only one question is, while the current regime provides for taxing income which is earned from cryptocurrencies, it doesn't make any provision or mechanism to set off the losses that are suffered by a party while trading in cryptocurrencies, right? You are seeking to put cryptocurrencies on the same footing insofar as taxation is concerned, on the same footing, right? As real currency, so to speak. Now, doesn't this create an unreasonable classification? Because while on the one hand, you're taxing income in the same fashion, but you don't provide a mechanism to set off losses. What do you have to say?
The issue of cryptocurrencies and NFTs and other virtual digital assets is a very contemporary topic. So right now, the many international bodies and even the G20 conferences and summits, they are concentrating on the legal framework that the country should follow to deal with these assets. But right now, the highest priority of the government is to regulate these assets, and this taxation, the step to tax the income earned through these assets is the first step towards regulating it. So hence, it is just the government is justified to tax these assets without having a proper mechanism right now. But the legal framework is still in process, and the government would soon come up with it.
Fair enough. Please, you continue your solution.
Okay, so the next case I would like to present is the case of Commissioner of Income Tax versus K. Tangapani, where the same was held that the taxes would be collected from the people irrespective of the legal status of the source of the income. Even the next thing the council would like to say is the United Nations Conference of Trade and Development has even urged authorities of countries to regulate crypto NFTs and decentralized wallets to ensure a more comprehensive regulation of these assets and the income earned through it. And it is and the regulation of these assets is extremely necessary considering the anonymity that blockchain technology offers and all the risks that come with it. That's it, Your Honor. My co-counsel would proceed from here. Thank you.
A very good afternoon, good morning, honorable bench. I'm speaker 2 from team 06. I would be dealing with the
Counsel, your
second.
voice is echoing.
Is it audible, Your Honor?
Yeah, it's better.
Shall I proceed, Your Honor?
Yes, now you can.
Much obliged, Your Honor. The second issue here is whether the section 115 BBH of Income Tax Act is in violation of Constitution of India or not. The Council of Respondent humbly submits before the Honorable Court that the section 115 of Income Tax Act is not at all in violation of the Constitution of India, as Constitution itself empowers the Government of India to impose tax on various individuals and organizations, including virtual digital assets. Firstly, the taxability under section 115 BBH of Income Tax Act. For taxation of virtual digital assets, a new section has been imposed, section 115, which states that 30% should be taxed on any income earned from the transfer of virtual digital assets. Before proceeding, the council seeks permission to refer to the constitutional provisions regarding taxation system in India. The taxation system in India has been given under 3 lists, Your Honor. The first list, the union list, the state list, and the concurrent list. The union list empowers the central government to impose or levy tax on all the subjects mentioned in the list. The state list empowers the state government to impose or levy tax on all the subjects mentioned in the list. And the concurrent list empowers both the governments to levy or impose tax mentioned in the list. The council would like to draw the attention of the bench by stating that the Article 246 and List 1 of Schedule 7 of Indian Constitution states that the Union government has exclusive right to impose or levy tax on all the subjects which are not mentioned in any of the lists mentioned above. So as virtual digital assets are not mentioned in any of the lists, it signifies that the union government has exclusive right to levy taxes on the income earned from the transfer of virtual digital assets. Now, the chargeability of Income Tax Act, as mentioned before, 30% is to be taxed from the income earned from the transfer of virtual digital assets. The Income Tax Act provides that every person whose income exceeds the maximum amount not chargeable shall be taxed under Income Tax Act at the rate prescribed under the Act. Here, the scope, the definition of income given by the Income Tax Act is very inclusive. Therefore, before reaching to any conclusion, we have to determine whether the receipts amounts to income under Income Tax Act or not. The scope of income here means all the income earned arising whether directly or indirectly through or from the business situated in India, through or from any property situated in India through or from any capital assets through or from any sale or transfer of capital assets situated in India shall be taxed under Income Tax Act. So as stated by my co-counsel in the first issue, the virtual digital assets are been classified as the capital assets under Income Tax Act. Therefore, the government is very well within the ambit of the constitution to levy taxes on virtual digital assets. Having said that, the council would like to now establish the Article 265. The Article 265 here states a very important constitutional provisions, namely which states that no tax can be levied except by the authority of law. Here, the authority of law means the statute or the act of legislature. Moreover, the law must be valid and should satisfy the following requirements. The first requirement is it should be well within the competence of legislature. It should be provided by the list given to the government and by the constitution, and it should not infringe any other constitutional provisions such as Article 27. Article 27 here states that freedom of payment of taxes if you are carrying a religious institution. As stated before, Your Honor, Article 246 and List 1 of the Schedule 7 exclusively give right to the central government to impose tax on any subjects which are not mentioned in any of the lists. So virtual digital assets are not mentioned in any of the lists, hence the government can levy taxes on it. Moreover, it would have been violative of the constitution if the taxes were imposed by any other authority except for law. Here, the law is only imposing the tax, and therefore there is no violation of the constitution. Moreover, there is no infringement of any fundamental right. So we cannot say that there is a violation of constitution. If Your Honor is satisfied with the argument, can we proceed with the prayer?
Please proceed.
Much obliged, Your Honor. In the above facts stated, arguments raised and issues addressed, the council humbly prays before the honorable court to dismiss the case, pass any orders which the court deem fit in the proper interest, conscience, and justice, for which the council of respondent will be obliged forever. Thank you, Your Honor.
With the permission of the learned judges, we may proceed with the rebuttals and the surrebuttals.
Please proceed.
Much obliged, Your Lordships. As far as my worthy learned friends have stated in issue number 1 and 2, I'd like to counter on few points, which are as my worthy opponent has stated that in the case of Muhammad Abdul Karim, firstly, the cases which has been cited by my learned friends are not in the ambit of section 115 BBH of the Income Tax Act. Secondly, the facts of the case are totally different than the facts of the case which we are having today. In the case of Abdul Karim, the case was relating to the partnership firm. There was some illegal tax earned, but in this case, it is not so. Also, there has to be some reasonability for gaining the tax by the government itself. If we see in today's time, when we invest in the long-term or short-term assets in the stock market, for the long term it is 10% tax, and on the short term it is 15%. So there is some reasonableness given for that. Coming to the UN Convention on this regularization, where it has been said by the UN itself that states should regulate the digital income because of few regulations such as it has blockchain and it is secured. But at the same time, such regulations have not been brought yet in execution. So just by saying or just putting that convention into picture is not going to regulate the income which is not yet happened. Also, my worthy opponent has mentioned in section 115 BBH that we totally agree. We are totally into their shoes that you have exclusive right, but the exclusive right which you have, the issue itself says that how are you justifying? Your Lordship, I'm repeating that how are you justifying the tax? Just because it is coming from anywhere, you, the authority, having the right to take the tax only. How the way it has not come, it is not the question. But the question arises that if it is coming, if you are taking the tax, what is the justification given from you, which yet it has not been given. Therefore, I'd like to quote Edgar Agar's quote, which says that justice may be blind, but it has sophisticated ears to listen to the problems of the citizens. Also, Article 265, which says without the authority of law. Your Lordship, my learned worthy opponents have said that the central government or the state government or the concurrent list itself. My time is over. Can I just sum up in a minute's time, if Lordship permits so?
Continue.
Yes. So the competence of this authority is given, but at the same time, the justification which they are justifying, which is yet not clear. Therefore, here I would like to cite one case, which is of Lord Krishna Sugar Mills versus Union of India. The sugar merchants, and I'm ending with this. So the sugar merchants had to meet some export targets in the promotion scheme started by the government. But if they fell short of the targets, then an additional excise duty was to be levied on the shortfall. The court intervened here and said that the government has no authority of law to collect this additional excess tax. What this means, in effect, is that the government on its own cannot levy tax by itself. Just because they felt so, they are charging 30% without any justification, which we are asking. And my worthy opponents, both of them have pushed around the thing, but have not yet justified it. Therefore, the tax by itself which has not been legalized, which should not be taxed to the citizens without having the justification of it. And that is all from my side. Much obliged, Your Lordship.
The council would like to answer the petitioner's counsel with the permission of Your Honor. Okay, so first, we'd like to address the case of Muhammad Abdul Karim that you have mentioned. The fact we were trying to establish here was that the legality of any kind of income does not have any bearing on its taxability. Here, the income earned was illegal, and even though it was illegal, the government had authority to tax it. It just says that we're just trying to say that the legal status of the income is irrespective when taxing statute comes into picture. Even though the tax might be legal, the income or the source of income might be legal or illegal, but the government has the right and the authority to tax the income. And the next thing that the Learned Council has mentioned is that it has been the government did not impose taxes or the 30% of tax just because the government felt like it. These taxes have been imposed by very well-qualified economists and the Ministry of Finance. The government does not do things just because they feel like doing things. Here, the government has authority to tax the income earned through the transfer of these assets, and moreover, there is also a necessity to regulate these assets, considering the risks involved with the anonymity that the blockchain technology offers. Hence, the government is completely justified to levy taxes. It has the authority to tax the income, and moreover, it is also necessary to regulate these assets and the income earned through them. That's it, Your Honor.
With Lordship's permission, may I sum up with 1 or 2 points?
I believe we are done. No, your time for rebuttal was already taken up.
We had also given sir rebuttal, so.
Oh, you have
if it's-
rebuttal.
Yes. Your Lordships,
Please
if you
proceed.
permit,
Proceed.
so yes, within 30 seconds of time, Your Lordships. So the legality and illegality of the income my learned friend has spoken in the case of Mohammad Kareem itself. It is not the question of legality, illegality of the assets which we are having in this case, but the justification. For that justification, my learned friend has answered that there were intelligent.
Speaker, you were on mute. Please repeat yourself.
For justifying it, has been said that by the legislature, by the well-versed, knowledgeable.
We've lost you again.
As far as this, as far as the question of justification, just for the sake of digital currencies, which is in the ambit of blockchain, but what about the NFTs and digital assets, which has not been yet justified, Your Lordships? And as far as the assets are concerned, gold, diamond, why the authority is only charging this assets at the rate of 30%? Why not other assets? So that is all. Much obliged.
Your Honor, we have already established the fact that the virtual digital assets are classified as capital assets. And our second argument was the legal status of the income does not bear anything on its taxability. So the Muhammad Kareem case has a persuasive value. We are not saying that it is directly relevant to or the our case or the facts of the case are same as our case. We are saying that in that even here the usage of virtual digital assets has not been legalized. Even though it has not been legalized, the government can yet tax it because the legal status of the income does not have any bearing on its taxability. So we are taking that case as a persuasive value, saying that even though the source of income is illegal, the government can yet tax it. Taxability is different and the source of income is different. And the government is taxing or imposing higher tax on the virtual digital assets than any other capital assets because the risk involved here is more. That is itself a justification. It is a very contemporary topic. The government needs to first curb the risk involved, protect the interest of the people, then implement laws relating to it. Therefore, they are taxing higher because the risks are here also higher. Thank you, Your Honor.
Thank you, everyone. I would like to extend my gratitude to the learned judges and the speakers for the smooth running of this session. Before we wrap up, I would like to inform the learned judges to kindly fill in the score sheets and send it to the Moot mail ID. Before we wrap up, I would like to request the judges to kindly give feedback to the team members.
Sorry, should I begin?
Yes, sir, please.
Team 6, speaker 1. Your name?
Sharanya, sir.
Sharanya. Try to understand the question first here. You argued well, don't get me wrong. But there was a question which I put to you, which may or may not have been entirely relevant to the issue at hand. But you see, what happens is when you're actually arguing in court in real time, many times judges will end up asking you questions which, according to you, may not have too much relevance, right? But the fact remains that you need to answer them to the best of your ability at that point in time. And then make sure that you show the judge that you've been mindful of what he or she has asked you, and that it's of important, it matters to you that you satisfy them, right? And only after you've sought permission do you proceed with whatever your pre-written or pre-prepared arguments are, right? So that's pretty much the only thing I have. This applies to everyone. It came up with you, so I'm telling you. But beyond that, I mean, all of you all were good. So I don't really have anything to add. You all did a good job.
Thank you so much for the feedback, sir. I will be more mindful from next time.
Ma'am, do you have anything to add?
Construction background noise, so I'd rather not.
Is it coming from my end? Because there is some noise in my background. I'll just mute myself. So
No, it's coming from mine. Team 21, speaker 1, I think. Is it team 21? Yeah. I think you were racing against time, and we took a while to understand what you were trying to say. I understand that you were time bound, but try not to race so much that you're not making yourself clear in terms of what you're stating. That is the only reason why I asked you to go back onto your facts, because I could barely understand what you said. Apart from that, I think nothing more from my side. Best of luck to both the teams.
Thank you, sir and ma'am. Thank you.
Thank you, ma'am.
With that, we will end this session now.